Good afternoon, everyone. Welcome to Constitution Day. And I want to introduce our very first outside speaker since we became UIC, John Marshall. This is Professor Adam Winkler. He is a professor of law at UCLA School of Law. He is a specialist in American constitutional law, the Supreme Court, and gun policy. We managed to convince him to talk with us 2 times today. This presentation is going to be on his award-winning book, We the Corporations, How American Businesses Won Their Civil Rights. This was a finalist for the National Book Award, and it also won the 2019 Scribes Award. And we have in the audience Professor Mark Wojcik, who is the president of Scribes. And so we're very proud of that achievement. Today at 5, if you like it, please come back at 5. He's going to be talking on his book, Gunfight, The Battle Over the Right to Bear Arms. And I love this in his bio. It didn't win any awards, but it was the answer on Jeopardy. Yeah, that could be even more impressive. Professor Winkler, not only has he published many scholarly books and articles, but he also has had pieces published in the New York Times, the LA Times, the Washington Post. His works have been cited by the U.S. Supreme Court. And one way he came back into my memory, because I met him at the Scribes Award ceremony, is that he's been on Adam Ruins Everything and on Factually, a new podcast. So if you're into those things, take a listen. He did a great job on that. He earned his Bachelor of Science in Foreign Service from Georgetown, his JD from New York Law School, and New York University. Let me get that right, because they're two schools that have similar names. And he also earned an MA in Political Science from UCLA. After he graduated from law school, he clerked on the Ninth Circuit Court of Appeals, and he also worked in the LA office of a really well-known Chicago firm called Cat & Mushin. And one of his cases that he said drove him back into academia, he was on the defense team for Michael Jackson in one of the child molestation cases. So he has had an interesting career as a lawyer. His dad is an Academy Award-winning producer, like Rocky, anyone, Goodfellas, things like that. And as a child, you got to appear in a movie with Liza Minnelli and Robert De Niro, New York, New York. So he also has some acting chops. So please welcome our very special guest, Professor Adam Winkler.
Well, thank you so much. It's really an honor to be here. Thank you to Dean Dickerson and to the wonderful staff here. That's made my visit so much fun already. Corporations have been at the center of some of the most high-profile, controversial cases before the Supreme Court in recent years. In 2010, in the Citizens United case, the Supreme Court held that corporations have the same free speech rights as individuals and allowed corporations to spend unlimited amounts of money to influence elections. Now, there are some people out there who worry that Citizens United will lead to a corporate takeover of American democracy. I think that's kind of silly. We all know corporations took over American democracy a long time ago. In 2014, in the Hobby Lobby case, the Supreme Court held that for-profit business corporations have religious liberty under a federal statute, the Religious Freedom Restoration Act, and allowed a chain of craft stores to an exemption from a federal law requiring them to cover birth control in employee health plans. Corporate rights have also become a prominent issue in the battle for LGBTQ rights. You may recall the case from 2018 before the Supreme Court, the Masterpiece Cake Shop case, which involved a baker who refused to sell a wedding cake to a same-sex couple. And although we think of that case in terms of the baker, as the name of the case, Masterpiece Cake Shop, indicates, it was really about the rights of his business to refuse to provide those services. Indeed, today corporations have nearly all the same rights as you and me, and they use those rights to challenge laws that regulate businesses and the economy. And so how did corporations come to have our most fundamental rights? Of course, corporations don't march in the streets with signs saying corporations are people too. It would be fun to see the Jolly Green Giant and Ronald McDonald walking down Main Street, I guess. But corporations, like other groups that have fought for equal rights from racial minorities and women, corporations have also fought a 200-year battle in the Supreme Court to win Supreme Court rulings recognizing their rights under the Constitution. In law school today, students are likely to learn about civil rights, women's rights, LGBTQ rights, immigrant rights, even states' rights. But I wish to suggest that there has also been a 200-year history of corporate rights in America. Now, the first thing to know about the fight for corporate constitutional protections is that it's been going on for a long time. The first Supreme Court case explicitly on the rights of African Americans under the Constitution, Dred Scott, was decided in 1857. The first Supreme Court case explicitly on the rights of women under the Constitution, Bradwell versus Illinois, was decided in 1873. By contrast, the first Supreme Court case explicitly on the rights of corporations was decided a half-century before these cases, in 1809. The corporation involved in that case was the Bank of the United States, at the time the richest and most powerful corporation in America. At a time when most businesses were highly localized, the Bank of the United States had branches all the way from Boston down to New Orleans. And of course, the battle over the Bank of the United States, which was a big partisan issue in the 1790s, led to the split among the founding generation and created the two competing political parties. The controversy over the bank, maybe more famously, also gave us a rap battle in Hamilton the musical. And the bank was despised by Jeffersonians, who, a little bit like perhaps opponents of Obamacare today, were determined to kill the bank by any means necessary. And in Georgia, lawmakers passed a special tax, and imposed it on the Bank of the United States. The bank wanted to challenge that tax in court, but it didn't want to go to federal court. It didn't want to go to state court in Georgia, where it thought that the Georgia judges might be beholden to Georgia interests. It wanted to sue in federal court. And the bank's case presented a familiar question. Are corporations people? Or more particularly, are corporations citizens under Article 3 of the Constitution? This provision, as many law students recognize as the basis for diversity jurisdiction, provides that citizens of one state have a right to sue in federal court when they sue citizens of another state. And this reflected the framers' fear of parochial interests controlling courts. And the bank, headquartered in Philadelphia, thought that it would be subject to those same biases if forced to litigate the popular Georgia tax in Georgia state courts. Now, of course, when the framers wrote this provision of Article 3, they weren't thinking about corporations. Indeed, the framers harbored considerable hostility towards big, powerful corporations. The Boston Tea Party, after all, was not just a protest against the British government. It was also a protest against the world's most powerful corporation at the time, the East India Company. In the early 1770s, the East India Company's profits plunged and threatened to bring down the economies of Europe. And the British government deemed the company too big to fail and passed an unprecedented bailout of the East India Company. And as part of that bailout, it gave the company the right, for the very first time, to sell tea in the colonies without having to use American middlemen. So the angry colonists that set out to dump that tea that night on that ship were mostly merchants who had been cut out of the profitable tea trade and were protesting the East India Company and threw overboard the tea of that company. Now, although there was no evidence that the framers of the Constitution intended to protect business corporations by their document, in a decision by the legendary Chief Justice John Marshall, the Supreme Court ruled that the Bank of the United States did have the right to sue in federal court under Article 3. Now, Marshall did not say that corporations were citizens, being that the provision really only protected citizens, but instead, Marshall said that corporations had the right to sue in federal court because they were made up of people, and the people who made up the corporation were citizens, and they had the right to sue in federal court. Even though the bank's lawsuit was brought in the name of the bank to recover the property that belonged to the bank, Marshall said that, quote, essentially the parties in such a case are the members of a corporation. The first case to extend a constitutional protection to business corporations, Bank of the United States versus DeVoe, is one of the neglected landmarks of American constitutional law. You won't find it in any constitutional law textbook, yet it laid the foundation for 2 centuries of corporate rights cases to come. And by the way, should you think that the right to sue in federal court is an insignificant and unimportant right under the Constitution, recall that that was the same right involved in the Dred Scott case. Right? In that case, the Supreme Court said in Dred Scott that African Americans could not be citizens under that very same provision of the Constitution. Unlike racial minorities, business corporations did have rights the white man was bound to respect. Now, after the Civil War, the 14th Amendment to the Constitution was added to overturn the Dred Scott case and to provide for equal rights for racial minorities. The 14th Amendment, as many of you know, prohibits states from denying any person within its jurisdiction the equal protection of the laws. This language was designed to ensure that states did not discriminate on the basis of race. But in a remarkable series of cases in the 1880s, the Southern Pacific Railroad Company fought to extend the 14th Amendment's guarantee of equal protection of the laws to business corporations. When California imposed a special tax on the railroads, the Southern Pacific Railroad claimed that the law discriminated against the corporation because it was a corporation. The company argued that California was denying it equal protection of the laws. To make this bold argument, the Southern Pacific Railroad assembled an all-star dream team of lawyers. Now, of course, lawyers have always played a starring role in civil rights movements. Think of Thurgood Marshall in the civil rights movement or Ruth Bader Ginsburg in the women's rights movement. Any movement that seeks to secure fundamental rights through Supreme Court cases must have really good lawyers to bring the cases, devise the novel legal theories, to write the briefs, and persuade the justices. And corporate rights were no exception. Among those who argued for the constitutional rights for corporations over the course of American history included legendary lawyers like Daniel Webster, who argued more than 200 cases in the Supreme Court in the early 1800s, and often considered the greatest advocate ever before the United States Supreme Court. John Quincy Adams, the 6th President of the United States, appeared in the Supreme Court to argue for corporate constitutional rights. And in a more modern vein, today Ted Olson, maybe considered the dean of the elite Supreme Court bar in Washington, has argued for corporate rights too. Unlike traditional civil rights organizations, which have always struggled for resources, for-profit business corporations have often been able to afford the best lawyers money can buy. Indeed, the Southern Pacific Railroad's lawyer was an illustrious and respected man by the name of Roscoe Conkling, a name you may not be familiar with today, but for 2 decades after the Civil War, Conkling was a leader of the Republican Party in the Senate at a time when the Republican Party dominated Washington politics. Conkling had even been nominated and confirmed to sit on the Supreme Court of the United States himself. Happening just earlier the same year that he argued the Southern Pacific's case before the Supreme Court. He had declined to serve, becoming and remaining to this day the last person to turn down a Supreme Court seat after having won confirmation in the Senate. Conkling frankly admitted that his reasons for turning down the Supreme Court seat were financial. He was simply making too much money as a lawyer for the railroads. Conkling and the Southern Pacific Railroad's other lawyers first adopted a strategy of civil disobedience. They would refuse to pay the tax. And then, a half-century before Thurgood Marshall's famous campaign against racial segregation, the Southern Pacific Railroad launched a groundbreaking set of what its lawyers called, quote, test cases, more than 60 of them in all, seeking a Supreme Court decision recognizing expansive 14th Amendment rights for corporations. The day that the Southern Pacific's case was heard in the Supreme Court, a newspaper headline captured what was at stake: civil rights of corporations. Now, the text of the 14th Amendment did not appear to grant corporations any rights whatsoever. It guaranteed the rights, as you've seen, of persons. But there's one thing you should know about Roscoe Conkling was that he was not the type of lawyer who would allow a little thing like the text of the Constitution to get in his way. And Conkling told the justices that earlier drafts of the 14th Amendment had originally guaranteed equal protection to, quote, citizens, but that the language was changed to, quote, persons he said, quote, to embrace artificial persons as well as natural persons. It was an audacious argument, but Conkling was unusually situated to make it. As a young congressman, Conkling had served on the very committee in Congress that had drafted the 14th Amendment. So when he was talking about the intent of the framers of the 14th Amendment, he was talking about his own personal experience. And indeed, Conkling, by the time the 1882 case before the Supreme Court came around, Conkling was the last surviving member of that committee. So there was no one there to question his account. Conkling even produced a musty old diary, he said, was a never-before-published journal of the drafting committee's deliberations, and a close study of the journal, he said, would reveal the desire of the framers to protect corporations, not just racial minorities. Now, there was one small problem with Roscoe Conkling's account of the history of the 14th Amendment, which was that it just wasn't true. We now know that the language of the 14th Amendment Equal Protection Clause was never changed in the way that Conkling said, from citizens to persons, and nor do the records show that any member of the drafting committee ever said or even implied that corporations would be protected when the amendment was proposed to the states and ratified after the Civil War. As one historian who examined the evidence closely concluded, the trusted Conkling had engaged in, quote, a deliberate brazen forgery to win new rights for corporations. Now, the Supreme Court actually never issued a final ruling in Roscoe Conkling's case, holding on to it for 3 years without issuing a decision. Some said this was due to a procedural snafu, although I suspect that Conkling's fraud was uncovered. Regardless, another one of the 60 Southern Pacific Railroad cases made it to the Supreme Court just a few years later. And it asked the exact same question of the court: are corporations protected by the 14th Amendment? But this time, there was no Conkling and no mention of his journal. And in the second case, the court ruled in favor of the Southern Pacific Railroad, although not on constitutional grounds. The court specifically said in the opinion, we do not need to reach this constitutional issue that's presented in this case because we can decide it on a statutory basis. But then the Southern Pacific Railroad's test cases took another bizarre turn. The court's opinions, as you know, are published in official reports known as the United States Reports, official volumes that are edited by someone known as the Reporter of Decisions. And by tradition, the Reporter of Decisions writes up a summary of the opinion and publishes it in the official volumes right before the Supreme Court's actual opinion. And this is helpful for lawyers and law students who are doing legal research. They can go and they could read the quick summary of what the court decided and before delving into the longer, more detailed opinion. The Supreme Court's reporter back in the 1880s was a man named J.C. Bancroft Davis. And Davis's summary of the Southern Pacific case said that the court had ruled, quote, the defendant corporations are persons within the intent of the clause in the 14th Amendment, which forbids a state to deny any person within its jurisdiction the equal protection of the laws. Now, we don't know exactly what motivated Bancroft Davis to include this obviously incorrect summary of the opinion. But if you're one who buys into conspiracy theories, you might be interested to know that J.C. Bancroft Davis had once served as the president of the New York and Newburgh Railway Company. Now, Justice Stephen Field was one who saw the opportunity presented by Davis's inaccurate summary. Field, if you haven't come across him before, was one of the most colorful justices ever to sit on the Supreme Court. He was the first justice from the Wild West, from California, and he was reputed to carry a gun with him everywhere he went, even under his judicial robes. He is also the only sitting justice of the Supreme Court ever to be arrested for a crime while on the High Court. And the crime in his case was murder. Now, of course, he was innocent, but we could say perhaps that he was guilty of one thing, which was that he was doggedly determined to extend 14th Amendment rights to corporations. Indeed, when the Southern Pacific Railroad's case was handed down, Field wrote a separate opinion to complain that the court had suffered a dereliction of its duty by failing to address the important constitutional question of whether corporations had 14th Amendment rights or not. Nonetheless, in a majority opinion a few years later, Field is writing it, and it's about corporations and about regulation, but it's not about the constitutional rights of corporations. And nonetheless, he drops in a sentence in that case saying, well, of course corporations have rights under the 14th Amendment. We decided that in the Southern Pacific Railroad case, citing to the official volume. Indeed, we know that Field knew that to be untrue, right? He had very specifically complained just a couple years before that the court had not ruled in the Southern Pacific Railway case that corporations had rights under the 14th Amendment. Nevertheless, in the years to follow, the Southern Pacific Railroad case would be cited dozens of times by the Supreme Court and by lower courts for holding that corporations are protected by the 14th Amendment, something that the decision simply did not address. Now, one reason Field was able to get away with his sleight of hand was because the court at the time was entering into a period of its history known as the Lochner Era, roughly from 1890 to 1937. And in the Lochner Era, the Supreme Court broadly read the Constitution in a lot of different ways to guarantee rights for businesses, striking down a host of different kinds of regulations, from minimum wage laws and maximum hour laws, federal child labor laws, some zoning laws. Meanwhile, in cases like Plessy against Ferguson, the Supreme Court refused to read the 14th Amendment broadly to protect the rights of African Americans, the intended beneficiaries of the 14th Amendment. Indeed, between 1868, when the 14th Amendment was ratified, and 1912, when a librarian set out to collect every Supreme Court case on the 14th Amendment, it was found that the Supreme Court in those 44 years had decided a grand total of 28 cases on the 14th Amendment rights of African Americans, most of them resulting, as Plessy against Ferguson did, in the African Americans losing their case. And during that same period of time, the court had heard 312 cases on the rights of business corporations under the 14th Amendment, many of them victories. The 14th Amendment, adopted as a shield to protect the rights of the most vulnerable minorities, had become and been transformed into a sword used by powerful businesses to fight back against regulation. Now, while the Lochner Era Supreme Court was indeed quite business-friendly, we know that, the justices of that era also imposed new boundaries on the rights of corporations. In a 1905 case, the court said that corporations had property rights under the Constitution, but not liberty rights under the Constitution. That is to say, they were protected from having their property seized by the government. Government just couldn't come in and take all of their inventory without paying just compensation. But the court said corporations did not have those rights that were associated with personal autonomy, bodily integrity, or political freedom. In a case evocative of recent controversies over businesses that refused to sell wedding cakes to same-sex couples, like the Masterpiece Cake Shop case, the Supreme Court in 1907 held that a corporation did not have a constitutional right to refuse to do business with customers it did not want to do business with. The corporation involved in that case was the one that ran Tanforan Racetrack up in Northern California, later home of the legendary Seabiscuit, and more disturbingly, the later home of an interned Fred Korematsu. And the corporation that ran that racetrack challenged a California law that prohibited places of public amusement from denying service to anyone with a ticket. If you had a valid ticket under this early anti-discrimination law, they had to provide you service. They couldn't keep you out. The company challenged that law as a violation of its constitutional rights. It said that the law violated its freedom of association, and said that the law was the equivalent of requiring a host of a private party to invite unwanted guests into their home. Nonetheless, the Supreme Court upheld California's law, and the court called the asserted right a liberty right, the kind of right that corporations did not enjoy. In another instance of déjà vu, corporations like the Lansing Brewing Company challenged campaign finance laws limiting corporate money in elections 100 years before Citizens United. In the early 1900s, some of the very first campaign finance laws were adopted, and they were bans on corporate money in elections. And in the run-up to Prohibition, the Lansing Brewing Company wanted to take out ads to try to convince voters to vote against going dry and prohibiting alcohol. And the corporation challenged these spending limits as a violation of their fundamental constitutional rights. Yet the courts consistently, in a series of cases, upheld the campaign finance laws, explaining that the right to influence elections was the type of right that belonged to natural persons, not artificial persons. The boundary between property rights and liberty rights established by the Lochner Court was blurred in the mid-20th century, and it began with the First Amendment. And the story of how corporations first won First Amendment rights highlights one of the surprising things I discovered in writing my book, We the Corporations, which was that corporations have often been innovators and first movers in constitutional law. Driven by the same pursuit of profit that leads corporations to be at the forefront of the economy, corporations have also played an influential role in the rise and establishment of important individual rights. In the early 20th century, the Supreme Court first began to strike down laws for violating the freedom of the press under the First Amendment. And again, some of the earliest and most important cases were brought by newspaper corporations. Just like the newspaper companies that fought back against the kingfish, Louisiana's iron-fisted demagogue, Huey Long, in the 1930s. If you're not familiar with Huey Long much, one way to think about him is that he was Trump before Trump. He was a boisterous populist who won election to the governor of Louisiana on the eve of the Great Depression, promising to make Louisiana great again. And when the newspapers in Louisiana came out against his political program, Long accused the newspapers of publishing fake news. You can't make this stuff up. And he stuck the big newspaper companies with a tax on their advertising. Long said his tax should be called, quote, a tax on lying, 2 cents per lie. Now, the newspaper companies challenged Long's tax in court as a violation of the freedom of the press. But the truth was, the law was really on Long's side at the time. The Supreme Court, up until that time, had insisted that the freedom of the press was only a restraint, only prohibited prior restraints. It only prohibited the government from limiting speech in advance, but didn't prevent the government from punishing speech that was wrong or from putting incidental burdens on speech, something like the advertising tax, which really didn't prevent the newspapers from publishing anything, but did cost them a little bit of money in their tax. The Supreme Court, nevertheless, issued a landmark ruling in favor of the newspaper corporations. And the court in that case held that the freedom of the press protected against any form of censorship, even if it was not a prior restraint. And corporations were entitled to claim that right too. In a modern society, newspapers played an essential role in checking the government and encouraging democratic deliberation, and they were published by corporations. Indeed, in the years to follow, corporations would be involved in many other landmark freedom of the press cases, including New York Times Company versus Sullivan, which established the right to criticize public officials, and the Pentagon Papers case. Indeed, if you enjoyed the recent movie The Post, you may have found yourself at the end cheering for a business corporation asserting its First Amendment rights. The First Amendment rights of corporations expanded greatly in the 1970s, and strangely enough, Ralph Nader deserves a decent share of the credit. The famed consumer Crusader won a groundbreaking Supreme Court case that struck down a law prohibiting pharmacists from advertising drug prices, prescription drug prices. Now, Nader's goal wasn't to help businesses, it was to help consumers who often were poor, often had expensive prescriptions, but because of the advertising ban, they couldn't easily comparison shop to try to find the cheapest medicines. But Nader's victory in that case established two important First Amendment principles that have since been used to much greater success by corporations than by consumers. The first principle is that speech on commercial matters like advertising was protected by the First Amendment. Previously, the court had rejected the idea that commercial speech was covered by the First Amendment. But Nader's new doctrine, however, empowered corporations to challenge a wide range of laws restricting advertising, including overturning laws mandating graphic warnings on cigarette labels, laws requiring public companies to disclose the use of conflict minerals, and laws restricting advertising of alcohol and gaming. Indeed, thanks to the doctrine that developed out of Nader's case, known as the commercial speech doctrine, today about 50% of all First Amendment cases brought in the federal courts today are brought by corporations or trade associations that represent business. Indeed, recently, the head of Nader's public interest organization called for the entire line of commercial speech cases that grew out of Ralph Nader's victory in the 1970s to be overturned. You might think of it as a poignant example of constitutional buyer's regret. The second principle established by Nader's victory was that the First Amendment protected the rights of listeners, not just the rights of speakers. Because Nader represented consumers. He wasn't representing the big pharmacies or a pharmacist or the business people who were trying to sell drugs to people. He was representing the consumers. But this kind of posed a problem for his First Amendment case because the consumer's speech wasn't actually limited, right? If you collected this information about the prices of prescription drugs, you could take out an ad, right? This was a regulation of pharmacists. It wasn't a regulation of private individuals like the consumers. So Nader had to craft a special argument to win his case. He said the First Amendment protects this speech if it's valuable to the listeners, regardless of the identity of the speaker, and told the court, you don't need to rule on whether pharmacists have a free speech right to speak this stuff. The listeners have a fundamental right to hear what the pharmacists have to say. This view of the First Amendment became known as the listener's rights view of the First Amendment. And that theory would quickly be used by the Supreme Court to strike down the first laws restricting corporate money in politics. 30 years before Citizens United, the court first struck down a campaign finance law limiting corporate money in elections in a case called First National Bank of Boston versus Bellotti. The case involved a Massachusetts law that prohibited corporations from spending money to influence ballot measure campaigns. And the majority for the divided 5-4 court, the majority opinion was written by Justice Lewis Powell, Jr. Prior to joining the court in 1971, Powell had written a memorandum for the Chamber of Commerce outlining a program for the political mobilization of business. It was the era of Nader, consumer rights and environmentalism, and Powell's memo was a call to arms for corporations and business people to fight back, to preserve the free market from all of this regulation. Powell's memorandum was widely shared after he joined the Supreme Court, and today historians of that period credit the memorandum with inspiring a lot of businesses and business people to become much more politically active. In the Bellotti case, Powell had the opportunity to turn his memorandum into constitutional doctrine. Yet, after conference in the case, the private meeting where the justices meet and cast their votes on the case, Powell found his majority starting to slip away as one justice after another realized, wait, we're going to say that corporations have broad free speech rights and can't be limited in how they spend money on politics? That's problematic. And as one justice after another started to fall off, Powell found his answer in Nader's listeners' rights theory, which he used to try to keep the vote of Justice Blackmun, who had written the opinion in Nader's case. And Powell's opinion insisted that asking whether business corporations had political speech rights was, he said, quote, the wrong question. The campaign spending law infringed on the rights of listeners to hear what the corporations had to say. And the identity and the rights of the speaker, Powell wrote, were irrelevant to the decision. Listeners' rights, by the way, would also be used prominently in the Citizens United case. That 2010 decision, which struck down a law barring corporations from spending money on election ads for candidate elections, was written by Justice Anthony Kennedy. And his opinion for the court, surprisingly, never says that corporations are people and that corporations have the same rights as people. Instead, Kennedy's opinion, among other things, says that the identity of the corporate speaker is irrelevant. As we established back in the 1970s, he said, that if the speech itself is valuable to listeners, then it is protected, regardless of the identity of the speaker. Now, perhaps the most misunderstood aspect of the corporate civil rights movement, if you will, is the idea of corporate personhood. Many people blame corporate personhood for the Supreme Court's decision in Citizens United, although as I've suggested, it was not really at issue. It wasn't referred to in the opinion at all. And we have seen certainly that in some cases, like Roscoe Conkling's 14th Amendment cases, there was an effort to use the text of the Constitution where it says persons to include corporations on occasion. But surprisingly, I found that corporate personhood has not been the basis for most of the expansive Supreme Court cases extending constitutional protections to corporations. So what is corporate personhood first and foremost? Corporate personhood is a really long-standing, well-established legal principle in business law, right? All the way back in 1757, Blackstone, in his influential commentaries on the laws of England, wrote that corporations were, quote, artificial persons. Indeed, if you open up any introductory textbook on corporate law or business associations today, one of the very first lessons will be that corporations are, as Robert Clark's book says, quote, fictional but legally recognized entities or persons that are treated as having some of the same attributes as natural persons. Now, of course, to say that corporations are people is not to make an existential claim that corporations are people, are just like human beings. If you prick them, they do not bleed. But corporate personhood does mean, in business law, that a corporation is its own independent entity in the eyes of the law. The corporate entity is wholly separate from the shareholders or the members of the corporation. Indeed, Delaware Chief Justice Leo Strine, one of the nation's leading experts on corporations, says, quote, the whole point of corporate law is that a corporation is a distinct entity that is legally separate from its stockholders, managers, and creditors. That's why if you slip and fall at Starbucks, you have to sue the company. You can't sue the individual shareholders. The individual shareholders have limited liability. They are separate legal persons with separate legal rights and separate legal duties, and the duties of the corporation do not attach to the shareholders. Yet, when understood in this way, we can see that the Supreme Court over the years has usually ignored the principle of corporate personhood in corporate rights cases. Recall Chief Justice John Marshall in the Bank of the United States case, who explained that it's not that corporations were citizens, it's that the members of the corporation were citizens, and that the corporation could assert those rights to protect the members. Justice Sam Alito's opinion in the Hobby Lobby case takes the same tack, reasoning that the birth control requirement infringed on the religious beliefs and the religious liberty of the Green family, the owners of Hobby Lobby. Justice Anthony Kennedy's opinion for the Supreme Court in Citizens United also echoes this theme, describing corporations not as people, but as, quote, associations of citizens. In these cases, the Supreme Court rejects the core tenet of corporate personhood, the idea that corporations and their members are wholly separate legal entities with separate legal rights and separate legal duties. Now, over the years, surprisingly, the Supreme Court has occasionally treated corporations as their own independent legal persons, separate and apart from their members. Surprisingly, though, when the court has embraced this core tenet of corporate personhood, the result has usually been to restrict or to limit the rights of business corporations as compared to ordinary people. In 1839, for example, the Supreme Court refused to extend to corporations the privileges and immunities of citizens under Article 4 of the Constitution. This provision, as many of you know, means that if you move from one state to another, you're entitled to all the same legal rights and privileges of the citizens of the state into which you've just moved. Corporations seeking to operate in the growing national economy of the 1830s tried to use this provision to challenge state laws that imposed special requirements on out-of-state, or what they called foreign corporations, bonding requirements, special tax requirements, etc. The corporations involved in the 1839 case argued that since their members were citizens who were entitled to go to any state and to do business and to make contracts with locals on the same terms as locals, that the corporations should have that same freedom. The Supreme Court at the time was led by Roger Taney, who ruled against the corporations. Although much reviled today for his opinion in the Dred Scott case, Taney had one thing that today's opponents of Citizens United might appreciate, which was that he was a vigorous opponent of expansive rights for corporations. According to Taney, the key was corporate personhood. A corporation, he said, in his opinion, quote, is a person for certain purposes. When a corporation makes a contract, it is the contract of that legal entity, of the artificial being created by the charter, and not the contract of the individual members. Therefore, you couldn't look to the individual members and see what rights they had and just extend that to corporations. In Taney's view, the rights and duties of the corporate entity were not the same as the rights and duties of the corporation's members. The Supreme Court did something similar in the early 1900s in a case arising out of Teddy Roosevelt's famed prosecution of the trusts. Roosevelt tried to break up the tobacco trust first, and the criminal investigation of the tobacco trust, as part of that, the administration subpoenaed the officers of the corporation that ran the tobacco trust to testify before the grand jury. The companies claimed that this was a violation of their Fifth Amendment rights against self-incrimination to require their own officers to testify against the company. The Supreme Court, however, rejected that argument and said it was not self-incrimination because the company and its members were separate legal persons. And even though it was an officer of the corporation that was called to testify, you can't claim Fifth Amendment rights to protect someone else, another legal person, such as the corporation in this case. Fueled by the capital amassed with the corporate form and represented by the bar's highest paid lawyers, corporations have been fighting for equal rights for more than 2 centuries. They've used the courts and the Constitution to strike down business regulation and to secure their freedom in the marketplace. But corporations have also been constitutional first movers, helping to breathe life into important constitutional provisions like the First Amendment. And contrary to common belief, corporate personhood has really not been the keystone for expansive rights for corporations, and in fact has tended to be used more often to limit the rights of corporations. Citizens United and Hobby Lobby have brought the issue of corporate constitutional rights to the forefront of public attention, but they are, I wish to suggest, only the most recent chapters in a much older story, the story of the corporate rights movement, one of the least known yet most successful civil rights movements in American history. Thank you.